page 3 of the handout materials. So just to recap for where we left off from last class, we're talking about sources of law. And on this page, again, this will be for sure 100% a fill-in-the-blank question on the midterm exam. And just to give you some idea what I mean by that, I'll ask you, real simple, name 6 sources of law. Sometimes I'll ask you to put them in order of authority, depending on how I write the question, but it's all coming off of this page. So this is a really important page for this whole class because of the different types of sources of law that we have, the different, like we talked about last class, the different levels of authority. That was our poker game we talked about, in terms of which laws are higher, which laws are lower. So if I remember right, we had left off, we were talking about the United States Constitution. And again, just to recap, the Constitution, the United States Constitution, is the primary source of law, the highest source of law that we have in the United States. Now what that does is the 2 functions of the Constitution. Number 1, it organizes how government is set up. And as we talked about last time, we have 3 branches of government that are created by the U.S. Constitution. Article 1 creates the legislative branch, which is Congress, the House of Representatives, and the Senate. And the job of the legislative branch, the basic function, is to create law. We have Article 2, which creates the executive branch, the president, and then subsidiary administrative organizations under the president. The executive function is to enforce the law that is created by the legislative branch. And when we say enforcement, we're talking about various things, anything from, on the criminal side, investigating a crime, charging somebody with a crime, and then taking it to a court for a trial, or it could be from a tax standpoint, enforcing tax law through the IRS, or through administrative regulations such as OSHA, the Occupational Safety and Health Administration. They write rules governing workers' safety on the job and that kind of thing, or the Federal Aviation Administration, all of the different administrative agencies that we have. And we'll talk more about administrative law a little bit later on. And then finally we have the judicial branch. The job of the judicial branch, which is the U.S. Supreme Court and then lower level courts, is to interpret and apply the law to a particular case. So those 3 branches of government that we talked about last time, the legislative, the executive, and the judicial. Now, with that said, there's a couple things there from a test question standpoint I want you to know. Number 1, U.S. Constitution is the highest level law. It will override any lower level law. Federal, state, city, county, it does not matter. If a lower level law, any of these other laws, conflicts with the U.S. Constitution, just like in poker, the Constitution wins. And what we would say is that law would be unconstitutional, right? We use that term all the time. So if a city writes a law, for example, we're here in Monmouth, so let's say the city of Monmouth wrote a law that said that you cannot have a parade ever, never, whatsoever. I used to be in charge of the 4th of July parade here for years. And so if they wrote a law that said that, we would say, well, wait a minute, that's a city law, and that law is infringing upon the First Amendment of the U.S. Constitution. Under the First Amendment of the U.S. Constitution, number 1, free speech, and number 2, the right to peacefully assemble. Those are 2 rights that are guaranteed under the First Amendment of the Constitution. So that's city law. So let's say we went out and had a parade and we got a violation for that. We would fight that and we would say that that city law infringes upon a protected right under the U.S. Constitution, the First Amendment. And therefore that city law is unconstitutional because it's too broad. Never, ever, ever having a parade would be too broad. Now, laws that limit, it's called time, place, and manner, reasonably limit when you have a parade, how much noise you can make, if you have to have insurance and those kind of things, those will be permissible. But a law that says never, ever would not be. So I don't want to get into those intricacies, but what I mean by this is this idea of higher level laws and lower level laws. A lower level law, if it conflicts conflicts with the higher level law wins. The lower level law is either unconstitutional or preempted, overridden by a higher level law. That's a fundamental right. We talked about that last time under the concept of supremacy. Federal laws override state law, and also under the idea of separation of powers. And I think that's about where we left off, was the idea of separation of powers. So let's just talk about that concept again. We're still talking about the Constitution. That is the organizational function, dividing the government into three branches. Now you'll notice over here on the side, you may be wondering what I've written there, L, E, L, E, J. That refers to which branch of government creates that source of law. So the U.S. Constitution, and anywhere where I have L, that is the legislative branch. Where I have E, like under treaty law, which we'll get to in a minute, that is the executive branch. And J would be the judicial branch. So one of the things I want you to know for this class, from a test standpoint, is number one, what are the two purposes of a constitution? Organize government, and then define and reserve rights of the people and of the states. Number two, what are the three branches of government? Legislative, executive, judicial. And then number three, I want you to know, and we'll talk more about this, which branch of government has the authority to create these various sources of law. So I might ask you, which branch of government creates a treaty? And the answer would be the executive branch, which we'll get to in a minute. Or which branch of government creates an administrative rule? That would be the executive as well. Which branch creates a statute? That would be the legislative. And again, we'll parse that out more in a few minutes. So back to this idea of the U.S. Constitution, the organizational side. I want to continue talking now about the concept of separation of powers. Having these three separate branches of government. It's a fundamental concept of the United States legal system throughout all levels. Federal, state, city, county, all levels of government, we have the same idea of separating powers. And again, the historical background on that, when the Constitution was created, was the idea that we want to spread these fundamental ideas and powers of a government out, so that not one person or not one group, small group of people have the power of government as a whole. So we separate the legislative, the executive, and the judicial into separate branches. That way we have a separation or a spreading out of the power to avoid a monarchy or a dictatorship or whatever you want to call it. So like we talked about last time, let's flip over real quick to page, page 10. Page 10. We talked about this page last time. Again, this is a possible fill in the blank question. It's also a true, false, or multiple choice question. What are the three fundamental concepts of the United States legal system that begin with the letter S? Number one, we've talked about, that is supremacy. Federal supremacy, the idea that federal law will override state law, but also supremacy at lower levels. A higher level state law will override a lower level state law if they conflict. That's the first fundamental concept. The second one is the concept of separation of powers. And that is the basic idea that these fundamental powers of a government are spread out among the three branches, legislative, executive, judicial, and that each branch has the power to act within that realm. So the legislative branch is making law, but not acting as a judge. A judge is not making law, nor is a judge acting as an enforcement, investigating and charging people with a crime, for example. That's not the role of a judge. The judge is there to hear a case that's brought to the court by the executive branch, by the district attorney or the attorney general, or whoever the prosecutor is in a particular case. Now, we talked about that last time, but what we didn't get into is this idea here, the outflow, or part of this concept of separation of powers is the idea of checks and balances. Now, most of you have probably heard that term before. It's a fundamental idea we've all heard ever since high school or whatever. But what does it really mean? It's part of the idea of separation of powers, that there will be checks and balances that are created by the U.S. Constitution. So first of all, what is a check? Not something you write on your bank account, right? Yeah, I mean, we call that a check. But what I mean when I say a check is the ability of one branch of government to halt or stop or modify what another branch of government is doing. A check is also the ability of an individual, like all of us, the ability of us to check the authority of government by contesting perhaps the validity of a law or an administrative rule, or to be able to go to court if we've had property taken from us, to ask that we be paid for that property as a taking. So a check is a limit on governmental power. That's basically what we mean. Like in hockey, you ever watch hockey, right? And they say you check somebody, what does that mean? You stop what they were doing. Maybe I throw somebody up against the wall in hockey, I'm checking them. So the idea of a check is a limit or a halt on governmental power. A balance is the idea, separation of powers once again. A balance is when the Constitution or some other provision requires that two branches of government cooperate, work together to do something, a sharing of power. So for example, a type of a balance is both the Senate and the House of Representatives must agree on a bill to send to the President for approval. Or the idea that when the bill goes to the President for approval in a proposed law, the President has to agree to it. It's a sharing of power. So while we're on that concept, let's flip over real quick to page 42, I believe it is. Yeah, page 42. Let's just take a look at these real fast when we talk about checks and balances. Okay. So, this is a list of some of the fundamental or basic checks and balances that flow from this idea of separation of powers, separate branches of government. The first one is the veto power. The veto power is the ability of a president, the executive, at the federal level, the President of the United States. At a state level, it would be a governor. We have the same concept in state law. It's the ability of the executive to say no to a proposed law that comes from the legislative branch. So if the legislature, Congress at the federal level, has a bill that they both agreed on at the House of Representatives and the Senate, that bill then is sent to the President for review. The President then has the ability to say no. I don't agree with that proposed law or the modification of that law, and therefore the President can veto the law. In other words, it doesn't become law. Veto the bill. It does not become law. So it's a halt by the executive branch, that's why I have E right here, against the legislative branch. That is, the executive branch has the ability to say no to a proposed law. Now, that is one form of check. Now, if the President agrees with the law, then the President would sign it, the bill, and it would then become law. So number two, if the President or a governor at the state level disagrees with the veto, by a supermajority vote, the legislative branch can override the veto. So then the bill that the President said no to would be overridden by the legislative branch by a supermajority vote, and that depends on if it's federal or state. It may be 60%, it may be 66 or 67%, it just depends. But the idea is the legislative branch still has the ability to enact a law even if the president disagrees with it. However, that must be done by a supermajority vote of both the House of Representatives and the Senate in order to overcome that veto. So that's essentially a check from the legislative branch against the executive, okay? So you have a check by the president, a veto, and then they override the check, kind of like a discount double check, right? You know? That's a bad thing, right? Okay. Now, obviously, that doesn't happen very often because it requires both sides, both political power, both political sides to agree at a supermajority level, and that's kind of hard to do, but it is available, and sometimes it does happen. All right, the next one, number 3, is impeachment. Impeachment essentially is the ability of the legislative branch to remove from office a member of the executive branch. Typically that refers to the president, but it could also be at a state level, a governor, if the state allows for impeachment, or it could also be a cabinet member, or it could be a judge. The legislative branch has the ability to impeach a judge. That does sometimes happen. A few years back, there was a federal judge that was impeached and removed from office for taking bribes, basically. And so it's the idea that the legislative branch, through the impeachment process, can remove a member of the executive or judicial branch if they've engaged in wrongful conduct, depending on what it is. So that is a check by the legislative branch on the executive and also on the judicial. So it's a form of a check. I forgot to go back, I need to go back to veto real quick, because I forgot to say something. Checks and balances. So the veto, when it's no, is a check. But if the president agrees with the proposed law, that's a balance. So it's kind of like heads or tails on a coin, in a way, right? A check is when they say no. A balance is when the president says yes to a law. So it's a sharing of power. All right, number 4, a treaty. We'll get into treaties in a few minutes, but essentially treaties have to be approved by the Senate. That's a form of a check on the executive power by the Senate. And I'll talk more about treaties in a few moments. And then we have judicial review, which we'll talk about more in detail in a little bit later. But basically the power of judicial review is the ability of a judge, that is a court, from the Supreme Court all the way down to a lower level court, perhaps in Polk County where we're at, to review a law or the action of the executive branch to determine if what was done was legally correct. And if a judge determines at a trial that the law was invalid, maybe it's unconstitutional because of supremacy, or perhaps a police officer did not get a search warrant when they searched a house and they should have done that, then a judge can say that action is invalid. Either it's unconstitutional or violated some higher level law, therefore a judge can overturn that action, override the law, override the search and seizure, or whatever the particular case may be. We call that the power of judicial review. And that's basically a judge overturning the action of another branch of government. Now those are the 5 primary ones I want you to know about. We also have a couple of other checks here. There are way more than this. This is just a handful that I pulled out. Another type of a check is what's called an independent check, and that is essentially your rights, your individual rights that you can raise as a check on governmental power. Your right to free speech, your right to freedom of religion, your right to be compensated if your property is taken from you, your right to an attorney if you're charged with a crime. Those are fundamental rights, and they act as a limit on governmental power. That's why we call them independent checks. They're independent of the branch of government. They apply to all branches of government, in essence, depending on how they're used. And then finally, we have an ex post facto. Does anybody know what ex post facto means? It's kind of a cool term. After the fact. This is a provision of the U.S. Constitution that prohibits a law being passed today that makes something that you did in the past that was legal then, illegal now, and then going back and prosecuting you for it. So let's say it was legal when I bought this coffee cup, and then they passed a law that said it's no longer legal to have a coffee cup. And then they went back and they saw my picture on YouTube or Facebook or whatever, and so they prosecute me for having my coffee cup a year ago. It was legal then, but now it's not legal. So they go back in time, a law that was passed now, and prosecute or penalize me now for something I did in the past that was legal then. That's unconstitutional. It's called retroactivity. You may have heard that term before. Some people call that a grandfather clause. You've heard that term perhaps? Yeah, that's where that flows from. I just like that term, ex post facto. I've actually had that happen a few times. I've had clients that have been charged with violating a rule that was passed now for something they did in the past, and they charged the person with it, and I went to court and said, Your Honor, this is ex post facto, and they agreed and threw out the case. So this also applies when they raise a penalty. So for example, let's say it is illegal to have a coffee cup when I bought it, but it's a violation subject to a $100 fine, and then they raise the penalty to a year in jail, and then they give me a year in jail for what I did back then. You can't do that. You can't up the penalty retroactively. So I don't want to get into too much in detail on that. I don't really get into it so much. These first 5 are really the main ones. And again, this is a possible fill-in-the-blank question. List 4 types of checks and balances. And that's what I'm looking for on that page. 75%, so not 100%, but high probability at 75%. And again, there are others. Pretty much any fundamental right that you have is a check, a form of a check that can be raised. All right, so let's go back to sources of law page, page 3. And let's continue to work our way through this list. Now again, as we talked about last class, federal supremacy, we have federal law, which is created at the federal government level. That's Congress, Senate, and House of Representatives. We have the U.S. Constitution, highest level law that we have. We also have state laws. And state laws, again, I have down below here because they are of lower level than the federal law. The state laws, when I refer to state law, I mean the law that's passed at the state level, Oregon, Idaho, Massachusetts, or whatever, by whatever the legislative branch in that state. In Oregon, we have the House of Representatives, the Oregon House, and we also have the state Senate, the Oregon State Senate. So it's modeled after the federal government. We also have, and every state also has, a constitution. And the constitution of the state has the same function as the federal constitution. That is, to organize how the government of the state is set up, and also to define and reserve the rights of the people within the state. So the same 2 functions at a state level. Now I just want to show you something real quick. You don't need to turn your page. I'll just put it up here on the overhead. This is on page 11, excuse me, page 5. No, page 11. This is the Constitution of the State of Oregon. And I just want to show you something real quick. I'll blow it up real big so you can see it. All right, this is Article 1 of the Oregon Constitution, the Bill of Rights. And so just like at the federal constitutional level, we have the first 10 amendments, which are the Bill of Rights. Within the state of Oregon, we also have the Bill of Rights in Oregon. So if you look here, Article 1, Section 1, natural rights inherent in people, freedom to worship, freedom of religious opinion, no religious qualification for office. On down the line, under Section 8, we have freedom of speech and press. So I'll just show you that one real quick. So this is Oregon's First Amendment, right to free speech. But at the state level, freedom of speech and press. No law shall be passed restraining the free expression of opinion or restricting the right to speak, write, or print freely on any subject whatever, but every person shall be responsible for abuse of that right. So that's Oregon's version of the First Amendment right under the federal Constitution to free speech. Now, I want to show you something here. Remember my funnel theory? I talked about that last time. Again, I apologize for flipping pages here, but there's my funnel. Remember, we talked about sources of law. Like the funnel, we start off with a higher source of law, that is the U.S. Constitution, which is very broad, it applies to everybody, but it's also very general. It's not very well defined. Right to free speech, what does that mean? So as we work our way down these sources of law, like a funnel, the laws become more specific and more detailed, but they apply to a smaller group of people. So this is an example of that. So we have, at the state of Oregon level, Section 8, which is much more detailed than the First Amendment right, which says Congress shall pass no law abridging freedom of speech, which is not very detailed. This is much more detailed. This is saying that you can't pass a law, speak, write, or print. So that expands your right just in that one sentence. Now what I'm showing you here, I'm not really going to test you on Section 8, okay? You don't need to memorize this page. In fact, after today, you don't really even need to look at it again. But I just want you to see in the real world, this is how this idea of this funnel idea. And oftentimes, the state constitution will actually give you more rights than the federal constitution. And I don't say more right. What I mean by that is a more definition to your rights. Now, for you guys, it's probably not going to be that much of a difference, but as an attorney, one of the things that we look for, we look at the U.S. Constitution, but we also look at a state constitution, because a state constitution may give you more rights within that state, and so if we're formulating a legal argument, we may find within a state constitution that you have more rights than are defined under the federal constitution. And that's something that can be raised in court, depending on the type of case. Now, I'm just showing this as an example. Again, I'm not going to test you on, what does Article 14 of the Oregon Constitution say. You don't need to worry about that, all right? This is just so you see what the law looks like in the real world. I also want to show what I mean by this funnel idea. So if you look over here just on the side, you'll see here there are 45